In the Burgess v. Tompkins case, Mr. Tompkins had been arrested and advised of his rights in accordance with Miranda, at which point two officers interrogated him about a shooting where one victim died. As recorded in the case, at no point did Mr. Tompkins say that he wanted to remain silent, that he did not want to talk to the police, or that he wanted an attorney. He was largely silent during the 3-hour interrogation, but near the end he answered yes when asked if he prayed to God to forgive him for the shooting. At trial, Mr. Tompkins moved to suppress his statement, claiming it had violated his Fifth Amendment right to remain silent and that these statements were involuntary. The question of Mr. Tompkins' motion made it all the way to the Supreme Court, which held that the state court's decision to deny the motion was correct. Tompkins' silence during the interrogation did not invoke his right to remain silent. A suspect's Miranda right to counsel must be invoked unambiguously. If the accused makes an ambiguous or equivocal statement or no statement, the police are not required to end the interrogation or ask questions to clarify the accused's intent. The Burgess court relied on the case Davis v. United States. However, while the case did involve Miranda rights, it did not involve the right to remain silent. Petitioner, a member of the United States Navy, initially waived his right to remain silent and to counsel when he was interviewed by Naval Investigative Service agents in connection with the murder of a sailor. About an hour and a half into the interview, he said, "Maybe I should talk to a lawyer." However, when the agents inquired if he was asking for a lawyer, he replied that he was not. They took a short break, he was reminded of his rights, and the interview continued for another hour until he asked to have a lawyer present before saying anything more. A military judge denied his motion to suppress statements made at the interview, holding that his mention of a lawyer during the interrogation was not a request for counsel. He was convicted of murder, and ultimately, the Court of Military Appeals affirmed. I contend that there is a fundamental problem with the decision in Burgess. Miranda does not protect a single right, but multiple rights. As the Miranda court stated, the police did not effectively advise him of his rights to remain silent or of his right to consult with his attorney. The Miranda court clearly identified two separate rights that the police need to advise someone upon arrest: the right to remain silent and the right to an attorney. These rights are different not only in form, but in function. The right to an attorney is a positive right. It identifies something the government must provide to the accused. The right is protected by the Sixth Amendment, which reads, "In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense." Now, the right to remain silent, more accurately, the right to not witness against yourself, is a negative right because it's what the government cannot do to you: compel you to witness against yourself. This is protected by the Fifth Amendment. No person shall be compelled in any criminal case to be a witness against himself. So when the Burgess court found Tompkins waived his right to remain silent when he knowingly and voluntarily made a statement to police, a waiver must be the product of a free and deliberate choice rather than intimidation, coercion, or deception, and made with a full awareness of both the nature of the right being abandoned and the consequences of the decision to abandon it. The court was partially correct in that. By voluntarily making a statement to the police, he was waiving his right to remain silent under Miranda. However, the court made an egregious mistake when they held such a waiver may be implied through a defendant's silence coupled with an understanding of his rights and a course of conduct indicating waiver. No, Tompkins did not waive his right to remain silent. He simply did not exercise it for a time. Now, later, he did exercise it, recognizing that the police could not compel him to witness against himself, which leads us to Salinas v. Texas and the hole the court claims to have punched through the Fifth Amendment.